The rules for no-fault just cause have been tightened with a new law passed by California Senate. It's SB 567. This is an amendment to the Tenant Protections Act, otherwise known as AB 1482, or statewide rent control. Hi, I'm John Tyner, owner and CEO of Tyner Property Management. We manage about 1,150 homes in the greater Sacramento area, and I wanted to share some important information regarding SB 567, which has become law on April Fool's Day, no fooling, 2024. No fault just cause addresses 3 reasons within rent control that a landlord can give a tenant notice to vacate when the tenant has done nothing wrong. Number 1, remove rental from the market. Notice to terminate a tenancy related to withdrawal of the property from the rental market for no less than 12 months. Nothing about this portion has changed. Rule number 2 is moving a specific family member in. The rules are now more specific for this regarding who qualifies as the landlord's family. Family under the law is the owner or the owner's spouse, a domestic partner, children, grandchildren, a parent or a grandparent only. Then the rules further state that the family who moves in must reside in the property for 12 continuous months as the person's primary residence. Number 3 is a substantial renovation. Landlords may give tenants a notice to vacate in order to substantially remodel the property. When they do, landlords must also provide the tenant with a written notice that includes specific information, including a description of the substantial remodel to be completed and the expected duration of the repairs, or the expected date by which the property will be demolished or remodeled, and a copy of permits to undertake the substantial remodel or demolition. An improper notice to vacate is void under the law. Any termination notice that does not comply with any provision within this clause is void. So, a tenant would prevail if they were to fight their improper notice to vacate. But a worst case for landlords is if the tenant actually does vacate on an improper notice, and then comes back and sues for wrongful eviction. Wrongful eviction for actual damage award precedent is into the hundreds of thousands. Senate Bill 567 has teeth. Violators are subject to 3 times the actual damages in addition to punitive damages. It also authorizes local governing bodies to bring action for injunctive relief against the property owner. Imagine if a landlord has a tenant that is 50% below market rental value, and they give that tenant improper notice to vacate because they want to catch back up on the rental market. If that tenant vacated, they could subsequently bring a cause of action for 3 times the damage, which was their right to a significant rent discount and all costs to move. The statute of limitations would allow that lawsuit to be brought for up to 4 years later after the tenant vacates, because it's a written document. The best practice is to take the property off the rental market. No matter what the cause is, whether you're moving a family member in or doing renovation, the easiest one to document and defend is to remove the property from the rental market for a year. And whatever you do, don't put this property back on the rental market before 1 year has expired. We have more information to share, so be sure to like and subscribe, and we'll talk to you next time.
John Tyner and/or Tyner Property Management do not provide tax or legal advice. John is neither an attorney nor a tax professional. This material is prepared for informational purposes only and is not intended to provide and should not be relied on for tax or legal advice. You should consult an attorney and/or tax professional for your specific needs and situation. If you would like to talk to us about professional property management for your rental home, you can reach us at 916-974-6003 or email us at info@tyner.com. And you can also visit our website at tyner.com.